This paper is a paper that I'm doing together with Luca, and which was the original starting point why we thought doing a conference in this area is a good idea. What we're talking about is also similar to Lars, different forms of collaboration between fintechs and banks, and we are proposing a fintech mentorship regime. So in a nutshell, this paper is to be seen in a tradition of research trying to investigate how to best build a fintech ecosystem, how to also encourage innovation in the fintech space. And we are putting center stage the idea of collaboration between fintechs and established banks. And that has many positive sides. As we'll see, banks may provide startups with access to know-how and to reputation, and very importantly, access to markets and going through the regulatory process. So banks can give a helping hand in many ways to the new startups on the fintech market. And our contribution is to propose an optional regime, an additional regime, which we call mentorship regime, for lack of a better word, which would allow fintechs to operate under a bank license of an established bank. That's in a nutshell the preview of the paper. Now let's start with the status quo. As we all know, a couple of years ago, the time Lars was talking about, the original fear when the first fintechs were emerging, or the hope, depending on which side you're on, was that fintechs are coming and they will disrupt, and they will disrupt the established players, they will displace them, so we won't have any real traditional banks in a couple of years. And we all know that this isn't really taking place. So what's happening is much more this type of collaboration, partnerships, interaction between them and the incumbent banks, and that takes a number of different forms and shapes. The advantages are clear. Fintechs get access to lots of customers and data that established banks have. There's a lot of knowledge, know-how, actually in both directions, in terms of technology on the one side and the traditional banking stuff on the other. But typically large economies of scale and synergies, and crucially, there is a marketing advantage, as we've just seen in the previous discussion, particularly when the established bank has a great reputation that may spill over to the fintech and give them some credibility. And finally, and this is somehow something that we'll put center stage, is that the partnership may give the fintech access to regulation and to banking services that they would normally not be able to do, and it gives them the possibility to improve their compliance culture. These collaborations that we're talking about take essentially three main forms, although you can classify and count them in different ways. What's happening right now is that many of these collaborations are already taking place through technology, through interfaces, these famous API interfaces, application programming interfaces. And we distinguish three main forms. So the first one is what you can call white label banking, or banking as a service, where the fintech operation is de facto integrated into the banking services. So the consumers perceive the service as being provided by the fintech. In other words, the customers who interact with the fintech don't really realize that they are de facto partnering, so that their contract is de facto with the bank. The fintech is integrated through technology into the bank, but to the outside world, to the customer, the fintech is the one that appears. And you, as a banking customer, you have to scroll down the screen to the very bottom to read in the small print. Actually, this fintech is powered by or is acting with the support of, or something like this, an established bank. The second type of fintech partnership that is already out there is the other way around. So you can call it white label fintech, or you can call it software as a service. Where it's the other way around, so it's the bank that is appearing to the outside world, and it has integrated the fintech's activities, the fintech service into what it does. Yeah, so the customer is simply dealing with his own stone old bank and doesn't realize that the bank is partnering internally with the fintech and using some of the technology that the fintech is offering indirectly. And the third form of cooperation are traditional joint ventures, co-branding partnerships, which are not necessarily the main focus of this paper. We are focusing on points number 1 and point number 2. I want to offer you 2 case studies to illustrate the point. The first one is Berlin-based bank N26, which in this white label banking stuff changed its role again and again. And it's an interesting case study because at the beginning, when it was a small fintech itself, it was partnering with a larger bank, and that a larger bank was Wirecard, which provided the banking license and helped N26 to get into the market. And then in 2016, N26 received the banking license itself. So it's now the major partner of smaller fintechs, a number of smaller fintechs that are partnering with N26 and that are using their license to grow. So these partners are integrated into N26, and the customer transacts with N26. So when you're opening an account with N26, you don't realize that indirectly you're also transacting a lot with lots of other fintechs that are enhancing the product portfolio that N26 is offering. So when I switch back to the classification before, N26 now is offering something in category 2, the software as a service category. It is appearing as a bank, a fully licensed bank to the outside world, and inside N26 there are a number of fintechs complementing their portfolio. By the way, N26 has just now expanded its activities to the United States. And there again, interestingly, they are the junior partner, and they're using a major bank because they don't have an American banking license yet to get into that market. Case study 2 is an interesting other example, Solaris Bank, which I think Lars was also mentioning before. This is an interesting case study because Solaris Bank is a fully licensed bank, but I guess not many people in this conference have ever heard of Solaris. The reason is that they are the ones who are not really appearing to the outside world a lot. Yeah, so their business model is to partner up with a number of startups and grant them market access on their banking license, typically against a fee. Yeah, so that's how they generate revenue. And I've given you a number of names, Tomorrow and Penta and QNIP. So these are all number of fintechs that are active on the market, but they appear to the outside world on their own, under their own name, right? So this is where then in the small print they would disclose that this is powered by Solaris. So Solaris itself has no or very little customer contact. It's mostly done by these startups. And this would be therefore an example of the banking as a service, where the bank is basically lending its banking license against a fee. A number of examples from other countries are on the bottom of the screen. Now, how does the law look at these types of partnerships? The legal perspective is that these are all, from a supervisory perspective, these are all categorized as outsourcing arrangements. Yeah. The payment service provider includes banking services in the client package, but outsources their provision to a bank, and the bank outsources the distribution of its services to a payment service provider. And so you can very validly ask the question, who's here the outsourcer and who's the outsourcee? But from a legal perspective, there is a clear answer. It's always the bank. No matter what shape and what form of partnership we're talking about, whether software as a service or banking as a service, it's always the bank that is outsourcing some part of its activities to another firm, which is maybe outside of the regulatory perimeter. And the economic substance obviously is somehow different, as we've seen, because the client may be completely unaware of the internal relationship between fintechs and banks. This type of outsourcing arrangement has been regulated around the world because supervisors are somehow keen to ensure that this type of outsourcing arrangement is not posing any risks. I'm just mentioning here as one example, the EBA guidelines from 2019, which have most recently been updated 2019, but there are many other very similar frameworks in other jurisdictions around the world. And the key points are as follows. Anything that a bank is outsourcing is normally part of the regular bank's risk management. So they do it under their own responsibility. Therefore, as Lars was saying, they don't always have to disclose it. They don't even have to notify it to the supervisor. This is, by the way, different in the UK, but this, in the European regime, you don't even need to notify it to the supervisor that you're outsourcing some of the activities. And then the law poses a number of additional requirements when the outsourcing arrangement is deemed material. And this classification, whether it's material or not, is also the responsibility of the bank to make that decision. And when the outsourcing arrangement is material, there are a number of additional strings attached to it. For example, you're not allowed to outsource any key managerial responsibility. You are required as a bank to carry out an appropriate due diligence, whether the fintech that you're partnering with is suitable and has good and solid business case and everything. You need to have a written outsourcing agreement, and the supervisor must, under that agreement, be able to monitor also the outsourcee. So in other words, the fintech, the supervisor must have access to the premises and has examination and information powers vis-a-vis the fintech. Importantly, the outsourcee, so the fintech, is frequently not a regulated entity. So this is the key point that we're talking about. It doesn't, in most cases, it doesn't have a banking license itself. It's very frequently a payment services firm, but payment services regulation is very different than a full banking license, and it's more focused on conduct rather than stability. As I said, the supervisor has information acquisition powers, but it doesn't directly oversee the fintech. It doesn't have early intervention powers or sanctioning powers. The design of these rules is that the supervisor is overseeing the bank, and the bank in turn is having a number of contractual rights vis-a-vis the fintech. So this is how the regular legal regime is designed at the moment. Now we are asking whether there are any problems with this, whether this framework is suitable, whether there might be any supervisory gaps in what's happening at the moment. Interestingly, supervisors, including the German BaFin, for example, seem to encourage this outsourcing. They are happy with this, right? Which somehow surprised me a lot. But the simple explanation is, for them, it's quite useful to somehow outsource something themselves, right? So they outsource their own supervisory role and basically give the role to the bank to monitor what the fintech is being doing. There may be, however, some problems with this arrangement. For example, when there are some legal infringements by the fintech and they can only act against the bank, right? They don't have any direct intervention powers vis-a-vis the fintech. They can, of course, ban the bank ultimately from outsourcing, from the whole outsourcing arrangement, but that is a very inflexible remedy and may sometimes come late. They might not even have the power to detect this early on, in particular when the bank has incentives to delay or to obscure what's going on with the fintech. So what we're seeing in reality then is that there is something that we can classify as a contracting out of supervisory function. So this outsourcing contract and this technology arrangement that I've been talking about is in a way that the FinTech can act outside of the supervisory perimeter and is not directly within the remit of what the supervisor can responsibly control. So we're asking the question of whether anything can be done to nudge or to force these players back into the supervisory remit. And the obvious answers that are on the table are the famous regulatory sandbox. Some countries have experimented with offering an alternative to the mentorship regime. Just very quickly, the regulatory sandbox most people will have heard of, so I will not spend a lot of time. Can relax rules to improve market access for fintechs. This is not really the thing for the problem that we're addressing in this paper, because it's not the main purpose of the sandbox to get fintechs into the full license range or into the supervisory perimeter, and they have limited resources. They're sometimes really symbolic and not really fully achieving the purpose that we're talking about here. Therefore, our idea is to have another attempt, which is helping these partnerships between banks and fintechs and putting them on a more solid ground. And this is the complementary mentorship regime, which we are proposing. Importantly, it's an optional regime, right? So it wouldn't change anything mandatory. It wouldn't change the regime. It wouldn't displace the regime as we have it today. It was just an offer to everybody. And the idea is as follows: the bank would simply be able to extend its regulatory license to the fintech, typically in exchange for whatever Lars is detecting out of his data sets, fee, exclusivity, any term of consideration really. And it just communicates, the bank just communicates that decision to the regulator, which then cannot refuse the arrangement. And once the fintech is in, the fintech will be subject to full regulation and supervision as any licensed firm is. So what's the consequence of that? The fintech is subject to full regulation and supervision, and importantly, it would be allowed to outsource its own compliance and its internal control systems to the incumbent banks. It would be supported in these functions by the experience of the established banks, and it would be much relieved of the cumbersome process of applying for a banking license, which is a regulatory nightmare. Our idea is that the responsibility and liability remains with the bank. Therefore, there is a huge incentives ex ante to screening whom you're letting in. So the bank will have an incentive to, because itself will be on the hook, has a huge incentives to decide whom is letting in. What's the advantage? It would clarify the responsibilities, would clarify who's doing what, would bring the fintech within the regulatory parameters, so would address all those shortcomings that we've been talking about. It may facilitate communication between the fintech and the supervisor, because the incumbent is somehow in between with his experiences and can facilitate the exchange and the learning process on all sides. Ultimately, the incumbent bank functions something similar to a vetting process, right? It has a hands-on practical experience on what may be working and what not, so it may take that additional gatekeeper role. So in conclusion, we are moving along the lines of partnerships between banks and fintechs. We're generally seeing them a positive thing. We're just trying to facilitate them. And our idea is that fintechs can de facto travel on the bank's regulatory license or ticket in exchange for consideration, would leave the responsibility and liability on the bank, and hope that this would encourage an incentive to screening on the bank, just as any regulator would normally do. Thanks very much for your attention.
So thank you, Georg, for that excellent presentation. We now have Edmund Schuster, who will act as a discussant for this paper. So Edmund, if you want to share your screen, if you have slides, the floor, the screen is yours.
Yes, thank you. Can you hear me?
Yes.
Yeah, okay, fantastic. Thank you very much for this very interesting paper. I did read it with great interest, although with slightly less attention and time than I would usually have, because I have 2 little children. So this is a disclaimer and an apology in advance. So as we've heard, the paper highlights some problems, regulatory and supervisory problems that arise out of the context of fintechs interfacing with the regulated sector. I believe the paper argues very convincingly that the current framework is very likely to create the sorts of loopholes that can give rise to regulatory arbitrage, perhaps harmful regulatory arbitrage, and to inadequate supervision of fintechs. Those fintechs that choose to stay outside of the regulatory perimeter, at least for the beginning of their operation. It also demonstrates why regulatory sandboxes are not the answer, do not solve the problems the paper identifies. And then the paper proposes this optional mentorship scheme that would have the effect, or that they would hope has the effect of bringing the fintechs within our regulatory framework, while at the same time not overburdening them with regulatory requirements. We all know that regulation, especially the kind of ever-growing requirements in our financial system, can act as a very important, very significant barrier to entry, and have very likely have an impact on competition in this space. Now, before I discuss the paper, I want to be the first one to mention the coronavirus on a slide. I was wondering to what extent the current crisis will reshape this sector. So if you look at the fintechs discussed in the paper and all the types of fintechs that are really at the core of the argument, it seems to be the case that their existence is really owed to incredibly easy and cheap access to equity capital for currently very, very unprofitable ventures that you could say are kind of moonshot ventures that depend on some fantasy on the part of the investor about where this is going to end up. And the answer to justify the valuations we see has to be that those fintechs, or some of those fintechs, will ultimately replace a large part of our retail banking landscape. And I'm wondering whether the current crisis will have an effect on that. And my guess would be that it will have an effect, given the cash burn rates of many of those businesses and the unprofitability. So this is something that is probably worth taking into account. Now, the paper assumes, in a way, this is just kind of a side point, it assumes that the fintechs have superior technology. And I'm just wondering, reading the paper, I was wondering to what extent we actually have evidence for that. I mean, clearly they have superior user interfaces. But when it comes to the core technology, I don't think that we have very clear evidence that this is what is going on, so that they do have a significant technology advantage, as compared to just the advantage of starting from scratch all over again. So not being burdened with the legacy systems that we have in traditional financial institutions. And to the extent that is the case, I think I'll come back to that. This has has some implications on how attractive the proposed mentorship scheme would actually be for financial institutions. Georg explained his classification, their classification, white label banking versus white label fintech. And reading the paper, I was wondering whether we actually need this sort of distinction for the purposes of this paper. I think the argument is most easily made in relation to white label banking, really, and white label fintech, as Georg's example with N26 shows, can probably also be explained for the purposes of this paper as white label banking by the fintechs using the financial institution. So I'm not sure. It's certainly interesting to think in these categories, but I'm not sure whether we actually need this additional distinction or whether it would be sufficient to just follow the regulatory approach here and just look at the outsourcing relationship as one between the regulated entity and the unregulated entity, with the regulated entity being the outsourcer for the purposes of the argument. So in terms of the risks posed by the current model, I think the paper does an excellent job of outlining some of the micro risks that are the microprudential risks that fintechs may pose. We all have heard about this, move fast and break things idea or slogan, and I think there's a lot of truth to that. Not least because in a world where very unprofitable fintechs are able to raise large amounts of equity capital, it is often metrics that don't usually matter too much in the traditional space that drive valuations, such as monthly users or something like that, even if those users do not provide any meaningful revenue to the fintech. And so I think this could be the source of significant risks. And this is a point where I think the paper could be expanded a bit. So some of the problems discussed, I'm not sure they are unique to fintechs, so that there's a conflict or that there are differences between how a compliance officer looks at a new venture as compared to somebody who is more concerned with the success of the business without looking at risks too much. I think that is true throughout financial institutions, throughout their operations. It's the conflict that always exists. So when discussing those microprudential risks, perhaps it would be worth also discussing how the risk metrics that we usually use and our mechanisms to deal with those risks may not always be suited for a fintech world where there are completely different drivers of profitability. And by profitability, I just mean valuation. And so there could be, I think there's something that could be done in this space, but the arguments, and especially the example in relation to money laundering, I think the paper makes a very good point here that there are additional risks. Another way of perhaps putting this point is that, yes, those microprudential risks exist even within our traditional financial institutions, within those big banks that have different divisions, different functions. There will be some conflicts there, but because in the white label banking context, we have to rely on a specific contract between the fintech and the regulated entity. We have a problem with the incompleteness of contract. The contract will aim to create some incentives, but because you don't have direct authority on the part of the regulated entity, these contracts will never fully replicate and will never fully substitute the types of risk controls and management of microprudential risk that we see within financial institutions. I think the case made in the paper about the macroprudential risk is somewhat weaker. It's not clear to me that based on current evidence, we see any significant macroprudential risks. The paper mentions that we just don't know enough about it, and I think that is true. It is very difficult to predict exactly what kinds of risks we will see materialize in the future. But if you look at the business models of the biggest fintechs at the moment, it doesn't seem like there's significant macroprudential risk on the horizon. The paper also mentions shadow banks or fintechs turning into shadow banks. I think the current evidence we have is that if anything, they're kind of reverse shadow banks. They don't really do much with their money, and that is related to the point I made earlier about valuations being driven by metrics that have nothing to do with profitability. N26, for instance, explicitly said in an interview with the FT last year that profitability is just not something that they focus on, to be honest. Now, when it comes to the regulatory sandboxes, I completely agree that this doesn't solve the problems identified. I think more generally, it's very hard to see how, if you try to scale this up, the combination of advising a regulated entity and then regulating it, how you can square this. I think the point made in the paper, namely that there's a problem with the selectivity of those sandboxes. So basically the regulator gets to choose who can join the program, and that this may rule out marginal innovation. I don't think that the evidence bears this out, at least for the UK. So I've looked at past participants in the FCA sandbox, and so with almost every cohort, you find what I would regard as very, very marginal innovation there. So I'm not sure that this is the real problem, but I agree that selectivity can pose a problem. It certainly is a concern should be a concern for us, that the regulator essentially decides whether or not a venture is likely to be successful in the future, and then bestows on them a very valuable regulatory relationship, namely the membership in the sandbox. And the timelines of those sandbox regimes, yes, they are challenging, but here my question would be, isn't it a possibility to do a kind of a pre-sandbox white labeling and then go in the sandbox and thereby extending the timeline? And wouldn't that allow most fintechs to get into the regulated category within a reasonable time frame? Now, let me say a few things about the mentorship program. So I think this could be attractive to some fintechs, but I couldn't help but wondering whether the optionality of the regime is really self-defeating if you look at the stated purpose. So if we want to increase quality of regulation, why would the fintechs opt into that, and why would the financial institution, why would the banks move into this regime? So from the perspective of the fintech, you could say, well, it may feel a bit like a bear hug. You are bound to require more integration, more data sharing with the financial institution. And I think it has a very significant, or it would have a very significant effect on the fantasy that surrounds the fintech if ultimately you're so tightly integrated, which will be a requirement from the banks, but from a regulated person's perspective, you're so tightly integrated in operation that it's hard to see how you would then, on a realistic timeline, replace a financial institution, which I believe drives these valuations that we see. And so in a way, from the fintech's perspective, it could also be a concern that they say, yes, we are unprofitable at the moment, but one big advantage we have is that there's reducing demand for in-person services. You don't really need branches anymore, so we can kind of leverage the advantage of coming late to the party. We don't have those legacy costs. Other banks closing branches create negative publicity. We don't have any branches, so we have a cost advantage here. And so the question is, from the fintech's perspective, whether this tight integration and collaboration wouldn't just result in the traditional financial sector having more time to adjust, and thereby also driving down the valuation of those firms. Now, in a way, it would then appear that fintechs within these mentorship programs would risk being seen as mere brokers, and if they just are used as a front end to customers or as a technology to bring in more business to the bigger institution, the question is if that is consistent with the way they see themselves. It wasn't quite clear to me why the legacy bank would be interested in that relationship. Now I understand, and it's very clear in the paper, that this is obviously a question for the commercial agreement between the two, and that the FinTech may actually offer very significant advantages to the legacy bank by offering significant equity to the bank. At the same time, because this regime is optional, the ability or the willingness of the FinTech to give up equity has to correlate with the advantages over and above a white label banking service that they get from the legacy bank, and it's not clear to me how big this advantage really would be. So overall, I think, given this would be an optional system, it's unclear how the two main players would be enticed to join the system. Do the banks want to import the regulatory risk which they cannot control? And if they do want to control it and do control it, then the question is whether fintechs want to be basically a division of HSBC or whatever legacy bank you want. So my view reading the paper was, well, that's an interesting proposal, and if it were adopted widely, it would clearly improve the status quo. It would improve on the status quo by making our supervision work more efficiently and closing regulatory loopholes. But the gains, the advantages seem to be external, at least mainly external. And so I'm not sure how attractive how easy it would be to make this attractive. So this is my conclusion. I think it would lead to better regulatory outcomes, but adoption is a problem. I also wondered whether you could actually make this mandatory in a way, so that would involve outlawing certain types of outsourcing arrangements or bringing more activities within the regulatory framework. Perhaps that is something that could also be discussed in the paper. But overall, I really enjoyed this very interesting paper. Thank you.
Thank you, Edmund, for that very thorough discussion. Georg, do you briefly want to take the opportunity to comment? And then I have 3 questions in about as many minutes.
So really, really quick. Thanks so much for these points. They were all spot on. And I should add that this project is very much work in progress, as you know. So we'll definitely take all of this into account. Let me just highlight 1 or 2 little points. One was, do we need the distinction between white label banking and white label fintech? I agree that our focus is mostly on white label banking, but the other thing is something I think still completely underexplored and would become really interesting if we move a little bit beyond fintech and think about big tech, you know, as partnering with software providing, and then we might have very different supervisory problems the way ahead. So this would be the next step actually to look at and to use our thing. Your main focus was on the incentives for the different players, and maybe I should clarify this a little bit. So the incentive for the fintech to move into this scheme would be, one point, it would gain flexibility because it would be subject to a full license, which would be much better than the contractual regime at the moment, where it's de facto, you know, just allowed to do whatever the contract tells it to do. You know? So it would have possibility of experimenting a lot with different things, all as if it had a full banking license. And at the same time, it would be able to outsource the compliance function to the bank, which I think should be attractive to fintechs getting into the market. It would be much faster to get into the market than doing it all by themselves. Right? So much for the fintech. And the key question, of course, this is something that Luca and I have been discussing a lot also, is, you know, what's in it for the bank? What's the bank gaining by all of this? And as you said, firstly, of course, the consideration, so the money, the equity or whatever the fee that they generate by this. But I think there's an additional point, which is they will be sharing the responsibility for supervising the fintech with the regulator, right? So they will not be doing it all by themselves and all under their own responsibility, but the supervisor will also have direct supervision of the fintech and will be much more involved themselves. So that in itself should also be an attraction of the regime. That in a nutshell was my 2 cents. Maybe Luca wants to add a couple of points, I don't know.
No, I would just add that possibly we shouldn't think just of legacy banks as potentially interested, but banks such as Solaris may act as a player if this was an available field for them.